lawmakers that maybe they made a mistake and it got repealed. So, yeah, I just, this is the final reading, so just be cognizant of that when we roll call the vote here. So we'll go ahead and, if there's no further discussion, we'll roll call it. And I will ask one thing too, just for clarity, that there are 4 council people present today. Mr. Kennan, what's that?
Motion to die.
All right.
I was going to add that I brought this for safety, not for and not for money, not to make revenue. But as for the ordinance, offered the item before, yes.
No.
Ron Robinson, no.
And Campbell is in that also. Item 11.
All right, before we get to item 11, we'll go over some ground rules on zoning ordinances.
I'm sorry.
So the following applies to agenda items L and N. They will be conducted as quasi-judicial hearings. What will happen is we'll read the title to the ordinance. We'll then open up the proceeding for all of those that wish to speak, be given the 3 minutes. The proposed zoning ordinance requires the City Council to conduct a public hearing in a quasi-judicial capacity. City Council's decision must be based on the evidence and information that is presented at the public hearing regarding the agenda materials, planning board recommendation, testimony presented at the public hearing, and the deliberations of the City Council. The City Council must make its decision based on the evidence in the record, much like a jury must do in a trial held at the courthouse. City Council's decision may not be based on any information received outside of the hearing process. The strict rules of evidence do not apply during the public hearing, but any comments must be relevant to the agenda item. In a quasi-judicial proceeding, the City Council is not allowed to take into consideration public sentiment or the popularity of a particular development proposal or request for a zoning change. The City Council may only consider the competent and substantial evidence that is presented to the City Council. The property owner or the applicant has the burden to prove that the application is consistent with the comprehensive plan and land development regulations. If that burden is met, the Supreme Court has explained the burden shifts to the governmental board to demonstrate that maintaining the existing zoning classification with respect to the property accomplishes a legitimate public purpose. Citizens who want to participate in a quasi-judicial proceeding can testify as to factual matters and any element of the case that would not require specialized training or specific academic degrees. Their testimony will be considered provided their testimony is backed up by established facts, studies, or evidence that is not conjecture or just based on a feeling. Non-expert testimony in a zoning case is perfectly permissible and can constitute substantial and competent evidence if it is fact-based. This can include eyewitness observation testimony about relevant facts and documentary evidence, including photographs, aerials, and maps. However, Florida courts have made it clear that mere generalized statements of opposition are to be disregarded, but fact-based testimony can be considered competent and substantial evidence. The quasi-judicial hearing process is not a popularity contest. Members of the City Council cannot consider anything that they encounter outside the public hearing on the application. Local, quote, politics can play no part in the decision-making process. Under Florida law, the City Council's decision must be based not on the members' personal preferences, but on the evidence that is in the public record. In Florida, the quasi-judicial system's decisions made by planning officials are to be based on substantial competent evidence and must be consistent with the comprehensive plan. One definition of competent evidence is evidence a reasonable mind could accept as adequate to support a conclusion. Competent evidence is generally testimony based on personal observation or testimony by an expert who has special knowledge of a relevant topic. For example, when addressing a question of traffic concurrency, the professional opinion of the traffic engineer is competent and may be relied upon as a basis for the decision. The opinion of a layperson who lives near a proposed development is not competent and may not be relied on. Neighbor testimony based on personal observations or on facts which they have relevant knowledge is competent and in some cases critical to the decision. For instance, I sit on my porch every morning at 7:30 drinking my coffee and traffic backs up to a certain intersection to my driveway a half a mile away, end quotes. Florida statutes 286.0115 provides that any person who is not otherwise prohibited by statute, charter provision, or ordinance may discuss with any commissioner the merits of any matter that the city council may take action. The following procedures, which remove the presumption of prejudice, shall be followed for ex parte communication. The substance of any ex parte communication with a council member which relates to a quasi-judicial action pending before the city council is not presumed prejudicial to the action if the subject of the communication and identity of the person, group, or entity with whom the communication took place is disclosed and made a part of the record before the final action on the matter. A city council member may read a written communication from any person. A written communication that relates to quasi-judicial action pending before the council shall not be presumed prejudicial to the action. Such written communication shall be made a part of the record before final action on the matter. Council members may conduct investigations and site visits and may receive expert opinions regarding quasi-judicial action pending before the council. Such action shall not be presumed prejudicial to the action if the existence of the investigation, site visit, or expert opinion is made part of the record before final action on the matter. So at this time, as to agenda item L, I would ask, has any city council member had any ex parte communication as I just described regarding the agenda item L?
No.
Record would show that all council members indicated no. All those who wish to testify speak at the appropriate time will be placed under oath. In addition to city staff or any other experts or the applicant that wishes to be part of the presentation shall be placed under oath. The order of the proceeding will be city staff will now make a presentation on the agenda item. And Mr. Gill, if you would administer the oath, and this oath would apply to Mr. Curtis as to item L and N, so we don't have to do them again.
All right, Mr. Curtis, do you swear or affirm that the evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
George Curtis, Development Manager, City of Live Oak. This is the second and final reading of a rezoning request for a property at 704 Duval Street Northeast. The request is to go from single-family zoning to a residential office. This did come before the Planning and Zoning Board in an advertised meeting on Monday, March 31st, where the Planning and Zoning Board unanimously passed a resolution recommending approval to the City Council. On Tuesday, April 8th of this year, City Council heard this request as a first reading and unanimously passed the first reading of the request. And last month it was tabled until this meeting. So I will submit for the record the staff report, the maps, photographs, and the memos that are contained therein on behalf of the city, and also an exhibit on behalf of the applicant, which is their letter of intent. Staff finds the request consistent with the comprehensive plan and points in the land development regulations, so approval is recommended from
And
staff.
also for the record, the planning and zoning documents of record related to the request will become part of the record.
Yes, sir.
All right, is the applicant present? If you wish to make a presentation? Just maybe briefly describe what your project is and your intent.
If you'll raise your right hand. All right, please administer the oath. Do you swear to affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name, please.
Letitia Robinson.
Thank you.
Our plans are to bring more homes here, affordable homes, to the area, build up the community, basically. The homes we are looking to do will basically go by the means of rent to own, basically, and be managed by a property management company in the area. and signing contracts just as if they were purchasing a home, 30-year contract as purchasing, and being managed by a management company here. But basically, to help those that are less fortunate or don't have the means to become a homeowner on their own. I'm a realtor and I see it a lot. There's a lot of single parents that would love to be in this position that just don't have the means to be in it. So that was my.
Any questions of the applicant by the council?
So we're speaking about the 704.
Yes.
Okay, what type of home are you planning to put there?
Single family.
A single family?
Yes, 2. Yes. Rezone it and put 2 single.
Put 2 single families there.
Yes.
One facing the street and one facing the other street?
Yes, ma'am. Yes, ma'am. Yes, a duplex, like type style.
Now, a single family or a duplex?
Well, single family, but they're going to be set up like duplex style. So they're single family homes.
Yeah, but
Townhome or-
yeah, we gotta make sure what we're talking about here. No duplex.
No duplex, just,
They have a whole separate house.
yes.
So, the requested zoning allows for a duplex or 2 separate homes, but it's one, property of record. So there wouldn't be a way, I don't believe, to build 2 homes and then divide the property and sell one half of the property to one person and one half to the other. They could remain as, and we'd have to look at the size of the home versus the setbacks and whatnot, but, they could remain as rentals on both sides, or they both could be sold to one person could live in one and then rent out the other. But the residential office zoning it's considered a small-scale multi-family zoning, which allows for more than one family to live on a property, but it's not a condo or townhome type zoning that kind of like Terra Trace or a planned kind of development where you would split it up into very small lots. We'd have to look at the minimum lot area for a home to determine if that property could be split or not.
So
There's
before
minimums.
anything was built, they'd have to go through the planning department.
Right.
To make sure there's enough room for setbacks.
Right,
Ingress, egress.
right.
So then are you saying, if there's not enough room, they would be probably putting a duplex?
I haven't even gotten that far, to be honest, because from the information I was provided, that there was enough room to place 2 homes on the lot. So this is new to me.
There may be enough room to place 2 homes on the lot, just not to rent to own them separately to 2 separate families. Yeah, because there's a code about that. But it all really depends on the square footage of each home. I included in the packet an example of a connected duplex being on the lot to show that would fit within setbacks, but we can evaluate it otherwise and see how much buildable area there is versus the size of the proposed homes.
And even if the zoning was approved, if the plan did not otherwise meet the requirements for setbacks and a division of 2 houses, then the permit would not be issued for 2 separate houses.
Right.
But you're saying that she can build 2 separate houses, but if she wanted to sell, she wouldn't be able to sell them separately. She would have to sell as one.
Right. We didn't look at the possibility of the property being split as part of this, because there's minimum width and minimum area for property, and we'd have to evaluate that to determine if that's another thing we do in-house, upon request, but,
Well, what's the likelihood of something, because, like I say, you have to look out for when people put this out there, when they think they're doing one thing and they're getting something else. I don't think it's, just really fair to the person
Right,
who's
because-
doing this right here. So what's the likelihood of, because it sounds like she had the intent of selling 2 units. What's the likelihood of of her being able to do that?
I can't say. I mean, generally people will hire an architect or an engineer or a survey company to do that kind of work, but we can do it in-house to give somebody an idea of what the possibilities are. But if you read the letter of intent, it says, the property is currently designated for conventional single-family dwelling, single-family residential use, and we respectfully request a rezoning to duplex residential use to allow for the construction and operation of duplex residences. So that's all I had to go by was your letter of intent, that where you said you wanted to do a duplex. And so this is the zoning that allows for that. So we didn't go any deeper because that's what we had to go by.
So even if you increase the density, that doesn't mean that they qualify to build up to that density, because unless they make really small homes, they have to have the setbacks on the front, back, and both sides.
Right. I think the minimum size home in the requested zoning would be 500 square feet.
But what I'm trying to prevent from happening is a disgruntled resident or a disgruntled person who's trying to build something and find out they can't do what they thought that they could do, and we pass and say yes, and now they're stuck.
Well, understanding you're not doing that. They've requested the zoning, so if they are granted the zoning, but there are other limitations within our code that prevents 2 houses, then they're stuck with the single-family house.
Okay, all right, so then they'll have to go by what?
They have to go by the building department once they submit a permit and a plan. Like the sketches we saw, like on the annexation, the setbacks, the ingress, egress, all of that has to be submitted to Mr. Curtis's office for approval.
Okay, so
Analyzing a lot of other sections of our code.
so they'll know before they start building what they can and cannot do. Okay,
Yeah,
instead
that's
of
a very
getting,
comprehensive.
laying a foundation and
Yeah.
then finding out, oh,
Yeah. We review everything and issue a written approval based on all the plans before the permit is issued. And then it's up to the contractor to follow the plans that were approved.
Any further questions of the applicant?
I'm so afraid it's going to end up a duplex.
So I was advised that the size of the lot, with the lot size, that we could build 2 homes on that lot. We've now knocked down the house that was there, cleared the entire lot, and we're ready to move forward. But understanding you're stating now that if it's approved for zoning, then once it's approved to be rezoned, then we will go and figure out what can go on the property at that point.
Up to the maximum density of that zoning classification.
All right. Thank you. Appreciate it very much.
Any public comments?
All right, seeing none?
And then staff have any final comments?
No.
All right, then we will close the public hearing at this time and then proceed to council deliberation.
Be the pleasure of the council.
I'll make a motion for ordinance 1531.
second.
Motion is second, discussion. Hearing none, all in favor? Aye. Opposed, like sign. Final reading of ordinance 1531 is approved. Moving on to agenda item M.
Yeah,
Okay.
I'll just read it real quick.
Okay, sure.
Make sure I get the right one here. All right, annexation. Ordinance number 1533, an ordinance voluntarily annexing certain real property into the city limits of Live Oak, Florida, and redefining the boundary lines of the municipality to include said property, providing for severability, conflict, and an effective date.
Thank you, George Kirsch, Development Manager. This is the second and final reading to adjust the city limits around a very small portion of property that was inadvertently left out of an annexation that took place back a few decades ago. So staff's recommendation is approval so that this property in its entirety will be in the city limits and the owner can move forward with development plans.
All right, do we have to have public
Yeah.
hearing as well? All right, this time we'll open up for public hearing. Anybody from the public care to speak on this agenda item? Seeing none, we'll close the public hearing section. Be the pleasure of the council.
I make a motion that we discuss with possible council action, ordinance 1533, annexation 25-02.
All right, motion is second. Any discussion? Hearing none, all in favor? Aye. Opposed, like sign. Final reading of ordinance 1533 is approved. Moving on to item N.
Item 1536, ordinance number 1536, an ordinance of the City of Live Oak, Florida, amending the zoning district to 0.89 acres more or less of land on the official zoning atlas of the City of Live Oak Land Development Regulations pursuant to an application LDR 25-02 by the property owners and/or their authorized representative under the amendment procedures established in Article 3 of the Land Development Regulations, providing for a change in the assigned zoning district from County Commercial Intensive C1 to City Commercial Intensive C1 on certain lands within the corporate limits of the City of Live Oak, Florida, providing for severability, repealing all ordinances in conflict, authority, and an effective date. And this likewise, for the record, is a quasi-judicial hearing, follow the same procedure as we did for agenda item L. And so we'll start with a staff presentation, and Mr. Curtis, for the record, has already been placed under it.
Thank you, George Kirsch, Development Manager. This is similar to the annexation request that was just approved in the respect that it's an inadvertent map omission that took place when this property was annexed in 2001. What happened was there was a subdivision that was created for commercial lots. The majority of all the lots fell in the city limits at the time.